A New York appeals court just delivered a devastating financial blow that threatens the foundation of Donald Trump's business empire. Judge Arthur Engoron's $454 million civil fraud judgment was upheld in its entirety, confirming findings that Trump systematically inflated asset values by billions of dollars to secure favorable loans and insurance rates over more than a decade. And this isn't some technical violation or accounting dispute that can be dismissed as business as usual. This is a judicial determination that Trump engaged in persistent and repeated fraud, misrepresenting the value of properties, including Trump Tower, Mar-a-Lago, and numerous other signature assets to financial institutions across years of transactions. When an appellate court affirms a fraud judgment approaching $500 million and includes language describing conduct as egregious and demonstrating a complete lack of contrition, and the implications for both business operations and personal wealth become catastrophic. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what specific findings triggered this massive judgment? And according to the February 2024 trial court decision now upheld on appeal, Judge Engoron concluded after a 3-month trial that Trump inflated the value of Mar-a-Lago by approximately 2,300%, claiming it was worth $739 million when the actual assessed value for property tax purposes was between $18 million and $27 million. The ruling documented that Trump valued his Trump Tower penthouse apartment at $327 million by claiming it was 30,000 square feet when the actual size was 10,996 square feet. Financial statements submitted to Deutsche Bank and other lenders systematically overstated net worth by amounts ranging from $812 million to $2.2 billion, depending on the year examined. This wasn't about subjective valuation differences or good faith disagreements between appraisers. This was about submitting financial statements containing demonstrably false factual assertions regarding property sizes, valuations, and asset characteristics to institutions making lending decisions worth hundreds of millions of dollars. And believe me, when an appellate court affirms findings of fraud spanning more than a decade involving dozens of properties and billions of dollars in misrepresented value, the legal and financial consequences extend far beyond the immediate judgment amount. Here's the full picture of what's been unfolding through the legal system. The case originated in September 2022 when New York Attorney General Letitia James filed a civil fraud lawsuit after a 3-year investigation that reviewed financial statements Trump submitted to lenders between 2011 and 2021. But the situation escalated dramatically on September 26 and 2023 when Judge Engoron issued a pre-trial summary judgment ruling concluding that fraud had been established as a matter of law based on the documentary evidence alone before any trial testimony was even heard. The subsequent trial ran from October 2023 through January 2024, featuring testimony from accountants, appraisers, banking executives, and Trump himself. On February 16, 2024, Judge Engoron issued his comprehensive 2-page decision finding Trump liable for fraud, conspiracy to commit fraud, issuing false financial statements, falsifying business records, and insurance fraud. The ruling imposed $354 million in disgorgement of ill-gotten gains, which with prejudgment interest calculated from various violation dates brought the total to approximately $454 million. The judgment also banned Trump from serving as an officer or director of any New York corporation for 3 years and appointed an independent monitor to oversee Trump Organization financial reporting for an extended period. Smash that like button if this is making sense so far. Here's where it really gets serious. When Trump's legal team filed their appeal to the appellate division, First Department in March 2024, they were required to post a bond securing the full judgment amount to prevent New York from immediately beginning collection proceedings against Trump. properties. After weeks of negotiations with bonding companies and reported difficulties securing the massive bond required, Trump eventually posted a $175 million partial bond in April 2024 after an appellate court temporarily reduced the bond requirement pending appeal. But that reduction was always temporary and contingent on the appeal's outcome. And now that the appellate court has affirmed the judgment, the full amount becomes immediately due, with interest continuing to accrue at approximately $112,000 per day. And let's be honest for a moment. Judgments approaching $500 million don't get affirmed on appeal unless the evidence of wrongdoing was overwhelming and the legal findings were thoroughly supported by trial testimony and documentary evidence. Here's what multiple legal sources say happened during the appellate proceedings. On September 26, 2024, exactly 1 year after Judge Engoron's initial summary judgment ruling, a 5-judge panel of the Appellate Division, First Department, heard oral arguments on Trump's appeal. Trump's attorney, Christopher Keese, argued for nearly 90 minutes that the case represented an unprecedented expansion of New York fraud law, that no lenders actually suffered losses because all loans were repaid in full, and that valuation differences do not constitute fraud when parties can conduct their own due diligence. The Attorney General's office countered that fraud liability does not require victims to suffer ultimate financial losses, and that lenders rely on accurate financial statements when setting interest rates and loan terms, and that the sheer magnitude and persistence of the misrepresentations established intentional fraud rather than innocent valuation disputes. On December 18, 2024, the appellate court issued a detailed 2-page decision unanimously affirming Judge Engoron's ruling. The opinion, written by Justice David Friedman and joined by 4 other justices, concluded that the trial court's findings were supported by overwhelming evidence that Trump's valuations contained objectively false statements of fact rather than mere opinions, and that the repeated nature of the misrepresentations over more than a decade demonstrated the persistent fraud necessary to justify the extraordinary remedies imposed. Legal observers who reviewed the appellate opinion noted that the court explicitly rejected each of Trump's primary appellate arguments and used unusually strong language describing the defendant's lack of credibility and continued refusal to acknowledge any wrongdoing. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely devastating for Trump's financial position. The appellate decision includes specific language that goes beyond merely affirming the judgment. The opinion states that the defendant's continued insistence that nothing was wrong with submitting financial statements containing objectively false information demonstrates a complete lack of contrition and justifies the stringent remedies imposed by the trial court. Justice Friedman wrote that when a sophisticated businessman repeatedly submits financial statements claiming a property is worth $739 million when it is actually worth $27 million and claims an apartment is 30,000 square feet when it is actually 10,996 square feet. Those are not valuation disputes, but rather objectively false factual assertions designed to deceive financial institutions. Court observers noted that this language makes any further appeal to New York's highest court extremely unlikely to succeed, because the appellate court has now found not only that fraud occurred, but that the misrepresentations were deliberate and egregious. That's when it became clear this isn't just a significant legal defeat, but a potentially existential threat to the Trump organization's business model and Trump's personal wealth. The bombshell moment in the appellate opinion came when the court addressed Trump's argument that no banks lost money. Justice Friedman wrote that fraud liability under New York law does not require proof that victims suffered ultimate financial losses. The statute is designed to protect the integrity of the marketplace and ensure that financial institutions receive accurate information when making lending decisions. He explained that when lenders extend credit based on false financial statements, they may charge lower interest rates or impose fewer restrictions than they would have with accurate information, and that difference constitutes harm even if loans are eventually repaid. This reasoning eliminates Trump's primary defense argument and confirms that the fraud finding stands regardless of whether Deutsche Bank or other lenders ultimately profited from their relationships with Trump. This ruling sent immediate shockwaves through commercial real estate markets and financial institutions that have relationships with Trump Organization entities. When an appellate court affirms findings that a major real estate developer systematically defrauded lenders for over a decade, it raises fundamental questions about due diligence procedures, the reliability of borrower-provided financial statements, and whether other undiscovered fraud may exist in the commercial real estate lending market. And several banks that previously did business with Trump Organization entities have reportedly initiated internal reviews of their underwriting procedures and past transactions to ensure they were not similarly deceived. This isn't the first time real estate developers have faced massive civil fraud judgments that threatened their business empires. Think back to the case of Leona Helmsley in the 1980s. The hotel magnate known as the Queen of Mean was convicted of federal tax fraud and imprisoned after prosecutors proved she had claimed millions in personal expenses as business deductions, while Helmsley's case involved criminal tax fraud rather than civil fraud against lenders. The fundamental pattern was similar. A prominent real estate figure systematically misrepresented financial information to gain improper advantages. Helmsley's business empire survived her conviction, but her personal reputation never recovered. And Tapper, she faced years of legal battles over back taxes and penalties totaling hundreds of millions of dollars. Then there was the massive fraud case involving real estate developer Sheldon Solo in the 1990s. Solo faced civil fraud allegations related to a failed condominium project where investors claimed he had systematically misrepresented financial projections and development costs. While that case was eventually settled for an undisclosed amount before trial, it demonstrated how even wealthy developers can face existential threats when fraud allegations are supported by documentary evidence of misrepresentations to investors or lenders. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget the Enron scandal of 2001, though that involved corporate accounting fraud rather than real estate valuation. Enron executives systematically misrepresented the company's financial condition through fraudulent accounting practices, inflating revenues, and hiding debts through complex off-balance sheet arrangements. When the fraud was exposed, Enron collapsed virtually overnight, shareholders lost billions, and executives faced criminal prosecutions, and the company that had been valued at $70 billion filed for bankruptcy within months. While Trump's situation differs because his is a civil case focused on property valuations rather than accounting fraud, the fundamental dynamic is similar. When systematic misrepresentations are exposed and confirmed through extensive litigation, the financial and reputational consequences can be catastrophic. Now, however, the stakes are even higher for Trump because the judgment amount of $454 million approaches or potentially exceeds his available liquid assets. And the 3-year ban on serving as a corporate officer directly threatens his ability to manage his business empire. The pattern across these cases is unmistakable. When sophisticated business people engage in systematic fraud involving financial institutions or investors, courts impose severe penalties designed both to punish the wrongdoing and to deter similar conduct by others who might consider misrepresenting financial information for competitive advantage. So what specific findings in the appellate decision make this judgment so difficult to overturn or avoid? According to legal experts who have analyzed the 2-page appellate opinion in detail, and the decision rests on several key factual findings that would be nearly impossible to challenge in any further appeal. The opinion documents that Mar-a-Lago was valued in financial statements at between $426 million and $612 million in various years, when the actual value based on deed restrictions limiting the property's use to a social club was between $18 million and $27 million. This represents not a reasonable difference in valuation methodology, but rather a deliberate decision to ignore legally binding restrictions that fundamentally limited the property's value. Here's the kicker. The appellate opinion includes detailed analysis of testimony from Trump's own expert witnesses who attempted to justify the valuations used in financial statements. The court found that these experts used methodologies that were fundamentally flawed, ignored legally binding restrictions on property use, and in some cases, simply adopted valuations that Trump himself had suggested, rather than conducting independent appraisals. Justice Friedman wrote that when an expert witness bases valuations on instructions from the client rather than objective market analysis, and when those valuations ignore legal restrictions that any competent appraiser would consider, the resulting numbers cannot be characterized as good faith valuation differences, but rather represent participation in fraudulent misrepresentation. Don't go anywhere. The most explosive part is coming next. And here's what should alarm anyone in commercial real estate or banking who relies on borrower-provided financial statements. This case establishes that New York courts will look beyond technical compliance with accounting standards to examine whether financial statements contain objectively false factual assertions. The appellate court emphasized repeatedly that this case did not involve subjective valuation judgments where reasonable. Experts might disagree. It involved statements claiming a property was worth $739 million when deed restrictions made clear it could not be sold for residential development, claiming an apartment was 30,000 square feet when building records showed it was 10,996 square feet, and claiming properties had certain characteristics or lacked certain restrictions when public records proved otherwise. Once financial statements cross the line from optimistic valuations into objectively false, factual assertions, courts will impose severe penalties regardless of whether lenders conducted their own due diligence or ultimately profited from the relationship. This puts Trump in an extraordinarily difficult position both financially and operationally. On one side, he faces immediate pressure to satisfy a $454 million judgment that grows larger every day through accruing interest. Satisfying that judgment will likely require some combination of selling properties, securing new loans collateralized by unencumbered assets, or negotiating a payment plan with the Attorney General's office. Each option creates cascading problems. Forced property sales typically result in below-market prices, particularly when buyers know the seller faces time pressure from a judgment. Securing new loans may be difficult or impossible given the fraud findings and the 3-year ban on serving as a corporate officer. And negotiating with the Attorney General's office requires admitting inability to pay the full judgment, which could trigger additional collection actions. On the other side, he faces operational restrictions that directly threaten his ability to manage his business empire. The 3-year ban on serving as an officer or director of any New York corporation means Trump cannot hold formal positions in Trump Organization entities incorporated in New York, while he can potentially transfer day-to-day management to family members or trusted executives. The continuing independent monitor will scrutinize all significant financial decisions and reporting to ensure compliance with the judgment. This level of external oversight is extraordinarily unusual for a privately held business and creates constant risk that business decisions could be second-guessed or challenged by the monitor. And here's the tricky part that makes satisfying this judgment so complex. Trump has repeatedly claimed his net worth exceeds $5 billion or even $10 billion, depending on the statement and time frame, but net worth and liquid assets are entirely different concepts. Most of Trump's claimed wealth consists of real estate holdings that cannot be quickly converted to cash without significant value loss. The appellate court's finding that Trump systematically overvalued properties by billions of dollars raises serious questions about what his actual net worth might be if Mar-a-Lago is worth $27 million rather than $739 million. If Trump Tower units are worth far less than claimed, and if golf courses and other properties were similarly overvalued in financial statements, Trump's actual net worth could be a small fraction of his public claims. Satisfying a $454 million judgment when actual liquid assets may be substantially less than represented becomes an existential financial crisis. Legal and financial analysts are calling this a watershed moment for commercial real estate fraud enforcement. Barbara Jones, the former federal judge appointed as independent monitor overseeing Trump Organization financial reporting, told the court in recent filings that her monitoring has revealed ongoing concerns about the accuracy and completeness of financial disclosures. And while she has not alleged new fraud, her reports suggest that the culture of aggressive valuations and incomplete disclosures that characterize the fraud period continues to some degree even under court supervision. This pattern raises concerns that even with external oversight, fundamental business practices may not have changed despite massive legal consequences. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even some conservative legal commentators who generally support Trump have acknowledged that the appellate decision rests on strong factual foundations that will be difficult to challenge in any further appeal. Jonathan Turley, a George Washington University law professor who has defended Trump in various contexts, stated in a television interview that while he questions whether the remedies imposed are disproportionate to the harm caused, the underlying fraud findings are supported by substantial evidence of objectively false statements in financial documents. He emphasized that claiming a property is worth 27 times its actual restricted value, or claiming an apartment is 3 times its actual square footage, goes beyond aggressive valuation into deliberate misrepresentation territory that courts will punish severely. So let's break down precisely what this judgment means for Trump's business empire and personal financial situation going forward. First, the immediate cash requirement is overwhelming. The judgment of $454 million plus continuing interest accrual at roughly $112,000 per day creates enormous pressure to generate liquid assets quickly. Trump has essentially 3 options. He can attempt to secure an appeal bond from a bonding company willing to post the full amount pending any further appeal to New York's Court of Appeals. However, bonding companies typically require collateral equal to 110% or more of the bond amount, meaning Trump would need to pledge assets worth approximately $500 million or more to secure such a bond, given that many of his major properties are already pledged as collateral for existing loans. Finding sufficient unencumbered assets to support a bond of this magnitude may be impossible. Alternatively, Trump can attempt to negotiate a payment plan or settlement with Attorney General Letitia James's office, and however, the Attorney General has repeatedly stated publicly that she is prepared to seize and sell Trump properties if the judgment is not satisfied, and has already taken preliminary steps to identify properties that could be subject to collection proceedings, negotiating from a position where the other side has already publicly committed too aggressive collection efforts is extraordinarily difficult, and any settlement would likely require Trump to acknowledge wrongdoing or agree to permanent restrictions that he has consistently refused to accept. Finally, Trump could simply allow collection proceedings to move forward and force the Attorney General to actually seize and sell properties through a judicial process. This approach would buy additional time, as legal procedures for seizing and selling real estate can take many months. However, it would result in public auction of Trump-branded properties under distressed circumstances, likely generating sale prices well below fair market value and creating devastating publicity, as Trump Tower or other signature properties are sold to satisfy fraud judgments, the reputational damage from such proceedings could make it impossible to secure future financing or partnerships, even for properties that survive the collection process. Second, the operational restrictions fundamentally alter how Trump Organization conducts business. The 3-year ban on Trump serving as an officer or director of New York corporations directly impacts his ability to make binding decisions for many Trump Organization entities. While he can potentially structure operations so that family members or executives hold formal positions while he provides informal guidance, such arrangements create legal risks that decisions could be challenged as violating the judgment if Trump is found to be exercising control through informal channels. The independent monitor will scrutinize major business decisions to ensure compliance, creating a level of external oversight that is virtually unprecedented for a privately held family business. Every significant transaction, financing arrangement, or partnership agreement will require documentation satisfying, monitor that financial statements and valuations used are accurate, and do not repeat the fraudulent practices that led to the judgment. Third, the reputational impact on Trump's business brand may prove even more damaging than the direct financial costs. Trump has spent decades building a luxury brand associated with success, wealth, and premium quality. Court findings that he systematically defrauded financial institutions by billions of dollars for over a decade fundamentally contradict that brand image. Luxury hotel guests, golf club members, and residential property buyers are paying substantial premiums for the Trump brand when that brand becomes associated with fraud and financial desperation rather than success and quality. The premium that consumers are willing to pay evaporates rapidly. Several Trump-branded properties have already removed the Trump name from buildings or marketing materials in response to various controversies. This judgment may accelerate that trend as property owners and licensees conclude that the Trump brand has become a liability rather than an asset. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate business and financial fallout, this judgment establishes important legal precedents about the scope of fraud liability in commercial real estate transactions. New York's Martin Act and Executive Law Section 6312 provide the Attorney General with broad authority to pursue civil fraud cases protecting consumers and businesses. This case demonstrates that those statutes apply with full force, even when the victims are sophisticated financial institutions capable of conducting their own due diligence. The appellate court rejected Trump's argument that banks should bear responsibility for any losses because they could have discovered the misrepresentations through independent investigation. Justice Friedman wrote that while lenders certainly should conduct due diligence, the law does not excuse deliberate misrepresentations simply because victims might have detected the fraud with sufficient investigation. Fraud liability exists to punish and deter false statements, not to reward victims who successfully detect deception. This scenario is causing significant concern within Trump's remaining business partnerships and licensing arrangements. Multiple Trump-branded properties operate under licensing agreements where Trump Organization receives fees for use of the Trump name but does not own or operate the underlying real estate. Reports indicate that several licensees have approached Trump Organization seeking to renegotiate or terminate these arrangements, concerned that continued association with the Trump brand in light of the fraud findings will damage their own business prospects. Some licensing agreements contain moral clauses or reputation provisions that arguably allow termination when the first licensor faces adverse legal findings of this magnitude. If multiple licensees invoke such provisions or negotiate early terminations, it would eliminate significant revenue streams that the Trump Organization relies upon for operating expenses. and debt service on remaining properties. Meanwhile, Trump himself continues to insist publicly that he did nothing wrong and that the entire case represents political persecution by a Democratic attorney general targeting him for his political activities and presidential campaigns. His social media posts and public statements characterize the judgment as a weaponization of the justice system and claim that all valuations used in financial statements were reasonable and supported by expert analysis. He has pointed out repeatedly that all loans were repaid in full and that banks made substantial profits from their relationships with Trump Organization entities, suggesting that no fraud can exist when the alleged victims profited from the transactions. Things escalated further when Trump's legal team announced plans to appeal the appellate division decision to New York's highest court, the Court of Appeals. The notice of appeal filed on January 3, 2025, argues that the appellate court committed legal errors in affirming such extraordinary remedies without proof that any financial institution suffered actual losses. The appeal brief argues that New York fraud law has traditionally required proof of damages or detrimental reliance, and that expanding fraud liability to cases where all parties profited represents a dangerous precedent that could subject any business to massive penalties for valuations that turn out to be optimistic. Stay with me. What comes next will completely change how you view the situation. But here's what makes Trump's continued defiance and appeal strategy so problematic from both a legal and financial standpoint. Every day that passes without satisfying the judgment, interest continues accruing at rates set by New York statutes, and that interest currently adds approximately $112,000 daily to the total amount owed over the weeks and months required for the Court of Appeals to consider whether to accept the case, brief the issues, hear oral arguments. If the court grants review and issue a decision, the judgment will grow by tens of millions of dollars in additional interest if the Court of Appeals ultimately affirms the appellate division decision or declines to hear the appeal. Trump will owe substantially more than the original $454 million judgment. Moreover, maintaining the appeal requires keeping an appeal bond in place. While Trump was able to negotiate a reduced bond requirement during the initial appeal to the appellate division, that reduction was temporary and discretionary. Now that the appellate division has affirmed the judgment, the Court of Appeals may require a full bond covering the entire judgment amount before considering any further appeal. Posting such a bond would require pledging hundreds of millions in additional assets as collateral, further straining Trump's financial position and potentially triggering defaults on existing loans that have cross defaults. Provisions. Legal experts immediately identified the appeal to the Court of Appeals as having minimal probability of success. The Court of Appeals accepts only a small fraction of cases for full review, typically limiting itself to cases that raise significant legal questions or where lower courts have issued conflicting rulings. Since the appellate division unanimously affirmed the trial court's decision with detailed legal analysis, and since no other appellate courts have issued conflicting rulings on similar facts, the Court of Appeals is unlikely to find that this case presents the kind of novel legal question that warrants discretionary review. Even if the court does accept the case, overturning unanimous decisions from both the trial court and appellate division would require finding clear legal error, which appears unlikely given the extensive factual findings supporting the fraud conclusion. This goes far beyond affecting Trump's personal financial situation. It establishes precedents that will influence how commercial real estate developers, lenders, and regulators interact in New York and potentially other jurisdictions. The ruling makes clear that submitting financial statements containing objectively false factual assertions to secure favorable loan terms constitutes fraud, regardless of whether loans are ultimately repaid. This standard will likely lead banks and other lenders to demand more rigorous documentation supporting valuations in borrower financial statements and to conduct more extensive independent verification of property characteristics and restrictions. Real estate developers who have historically provided optimistic valuations in financial statements may need to substantially change their practices to avoid similar fraud allegations if valuations later prove to be inflated. If this blows your mind, hit that like button right now. Here's the situation in the starkest possible terms. A New York appellate court has unanimously affirmed a $454 million fraud judgment against Donald Trump after finding that he systematically inflated property values by billions of dollars over more than a decade to secure favorable financing terms. The judgment includes findings that Trump valued Mar-a-Lago at 27 times its actual restricted value, claimed his Trump Tower apartment was 3 times its actual size, and submitted financial statements containing dozens of similar objectively false assertions to multiple financial institutions across numerous years. This is no longer about contested valuations or technical legal disputes. It's about whether Trump can generate sufficient liquid assets to satisfy a judgment approaching $500 million, while operating under court-imposed restrictions that limit his ability to manage his business empire, and while facing daily interest charges that add more than $100,000 to the amount owed. When an appellate court not only affirms a massive fraud judgment, but uses language describing the conduct as egregious and demonstrating a complete lack of contrition, we have entered territory where further legal appeals face minimal probability of success. If Trump cannot secure an appeal bond, negotiate a settlement, or generate cash through property sales or new financing, the Attorney General has already stated publicly that she will begin seizing Trump-branded properties through judicial collection procedures and selling them to satisfy the judgment. Keep a close eye on this rapidly developing story. Trump's legal team has filed a notice of appeal to New York's Court of Appeals, but that court accepts only a small fraction of cases for full review and typically limits itself to novel legal questions rather than disputes about factual findings. The Attorney General's office has already identified specific properties that could be seized if the judgment is not satisfied, and collection proceedings could begin within 30 to 60 days if no appeal bond is posted or settlement negotiated. Financial analysts and real estate experts are watching extraordinarily closely to determine whether Trump actually possesses sufficient liquid assets and unencumbered collateral to satisfy this judgment, or whether his claimed net worth of billions may have been as inflated as the property valuations that led to the fraud findings. Before we go any further, smash that subscribe button so you never miss content like this. Here's precisely where things stand right now. A $454 million fraud judgment has been upheld on appeal with detailed findings that Trump systematically submitted false financial information to lenders for over a decade. The judgment bans Trump from serving as an officer or director of New York corporations for 3 years and imposes continuing independent oversight of all significant Trump Organization financial decisions. Interest accrues at approximately $112,000 daily, while Trump explores options for appeal, settlement, or payment. Meanwhile, the Attorney General has publicly committed to seizing and selling properties if necessary to collect the full judgment amount. This isn't just another legal setback or temporary financial challenge that will fade from headlines. This represents a financial reckoning with the potential to fundamentally reshape Trump's business empire. What happens in the coming weeks will determine whether Trump can satisfy the largest civil fraud judgment in New York history against an individual, or whether Trump Tower and other signature properties will be sold at public auction to satisfy court-ordered disgorgement of profits obtained through systematic fraud against financial institutions. The comprehensive fraud findings are documented across hundreds of pages of trial testimony and appellate analysis. The systematic nature of the misrepresentations spanning more than a decade has been established through documentary evidence that Trump himself could not credibly explain. Now the business world watches to see whether someone who built a brand on claims of extraordinary wealth and business success can generate the liquid assets necessary to satisfy a judgment that may approach or exceed his available cash and unencumbered collateral. The financial stakes have never been higher. The fraud findings have never been more thoroughly established through multiple levels of judicial review, and the deadline for satisfying this judgment or facing property seizures has never been more immediate. Pause for a second and hit that like button if you're finding value in this comprehensive coverage.